Welcome back to another video with Hugh James, and I'm joined again today by Simon Ellis, and we're up in the London offices, and we're going to talk about the Armed Forces Compensation Scheme and the War Pension Scheme. So welcome, Simon. Thanks very much for joining us today.
Thank you.
So just tell us a little bit about what is the Armed Forces Compensation Scheme and the War Pension Scheme.
Well, the Armed Forces Compensation Scheme is a no-fault scheme. It basically operated from 2005 onwards. Prior to that, it was the War Pension Scheme, but they're both very similar and they serve the same purpose. The background to this is that historically, if you were serving in the military and you suffered an injury, you weren't permitted to bring a civil claim against the MOD for that injury. And that left people who were injured in a very unfortunate position because they had no right to redress, essentially. So these two schemes came in as no-fault schemes, and the idea behind them was that if you suffered an injury and it was as a result of your military service, so long as it was certified that that was the case, you didn't have to prove fault on anybody, and you would receive a payment to reflect the fact that you had the injury, and that will come through the scheme itself.
Okay, and what's the difference between the two schemes then?
It's only a question of time. I mean, there are slight differences between the way they operate and some of the applicability side of things. But I mean, one of the main differences, I suppose, to bear in mind, and it is a little bit counterintuitive, this, if you are injured before 2005, you claim under the War Pension Scheme, and there's no deadline or time limit for you to do that. If you are injured after 2005 and you have to claim under the Armed Forces Compensation Scheme, you have a 7-year time limit in which to bring a claim. And if you wait longer than that, in practical terms, it won't then be possible to bring a claim under the scheme. Now, it's a little strange because you would expect that the earlier scheme would have the deadline and the later one perhaps wouldn't, but it works the other way around.
Okay, so it's quite a marked difference between the schemes there then. And what kind of awards can be made under these schemes?
The awards are based on tariffs that are fixed centrally. They clearly vary depending on the injury that's sustained. So a very minor injury will attract a fairly modest award. If you have, let's say, a catastrophic PTSD claim, it can be a 6-figure award at that stage. It all depends on what the injury is and when it was sustained.
Okay. And what's the process for bringing a claim under either of these schemes? Does it differ or is it the same?
It's a similar process. There's an application form for both in which you have to give usual personal details, the background to the injury and the accident and what led to it and how it's affected you in your day-to-day life. That is then submitted under the scheme, and a decision is taken by the administrators as to whether or not the application meets the criteria, and if the application is successful, an award is made in accordance with the tariffs. If the application is not successful and is turned down, and that's actually a lot more common than you'd expect, then you, as an applicant, you have a right of asking for a review when it's sent back for someone else to look at. And if it's turned down at that stage, you then have a right of an appeal when it goes before a tribunal, independent tribunal, who will look at it and take their own decision. There are further rights of appeal after that, but it gets much more difficult then because you can only then appeal if there's an error of law, which in most cases is not the case.
Okay. And are there any problems with the schemes, really? Is there any kind of negative sides?
There are a number of problems. I mean, it's probably best to start with the benefit to the scheme, and the key benefit is the one I mentioned. It's a no-fault scheme. You don't have to prove any fault on the part of anybody in order to make the application. Where it falls down is the criteria that you have to meet to qualify for an award are very, very strict. And to give you an idea of that, we act for a large number of individuals in civil claims for hearing loss, and a large number of those have been medically discharged with hearing loss. The majority of those individuals who then put an application in under the schemes for hearing loss are turned down, and the reason for that that's given to them is that their hearing is not badly enough affected. Now, it does seem odd that your hearing can be so bad that you have to leave the forces, but it's not bad enough that you're eligible to bring a claim under the scheme, and that is one of the key weaknesses to it. And we see that it's not just hearing loss, it's across the whole host of injuries. The other principal difficulty with it are the awards themselves, which are very, very low in comparison to what you might get through a separate civil claim, for example. Okay. They haven't really kept, in my view at any rate, they've not kept up with inflation. they really are ripe for reform, but that again is a particular problem with it.
Yeah, and you mentioned previously there about somebody, the course of redress and appeal. What if somebody's been turned down previously but they haven't gone through all the steps to the end? So they've been turned down initially for a claim. Can they come back and pick it back up?
You can resubmit it in principle. You'd have to be resubmitting it within the time limits that we talked about for AFCS. And it's also important to bear in mind that the original application forms are still likely to be there. So if there are changes between the new information that's provided and the old information, that is going to be something that will be considered when the new application is made. But in principle, yes, it is something that you can revisit if you feel able to.
Okay, you did mention it at the start, but you've just briefly mentioned it again, time limits. Just recap them for me. So
yeah, under war pension scheme, no time limits. You can bring it whenever you feel able to. Under armed forces compensation scheme, typically 7 years from the injury occurring, after which, in all but very exceptional circumstances, it will be too late.
Okay, and would an individual need a solicitor to bring a claim?
You don't need a solicitor insofar as the schemes are designed to be dealt with by lay people without professional advisors. The only comment I'd make in addition to that, I suppose, is when we have a large number of clients who, for whatever reason, feel that they would like us to deal with the applications for them, because we are fully familiar with the different criteria that are applied and the different tariffs that apply, we're able to tailor those forms to make sure that they have the maximum chance of success. And we do tend to see that those people for whom we put an application in do tend to have a greater success rate and frequently get higher rewards than might otherwise be the case. So in principle, no, you don't need a solicitor. In practice, and again, it's another fault of the scheme really, because it shouldn't be this way, but the reality seems to be that if you get a professional advisor to help you with this, your chances of success tend to go up.
Yeah, it's the same across a lot of things, isn't it? You know, and they design them for layperson, but even some of the jargon, you just don't know what it means, you know, and you spend all day Googling what the terminology is, and you're not going to get the answer right and the definition right.
I think that's right. I mean, it's quite striking. The main question we get, going back to the hearing loss example, is someone who makes the point I made, well, I've been discharged from the military, surely that's bad enough. Surprisingly not, and that's the point that a professional can help with, to try and address the application in such a way that that's dealt with.
Okay, so just going back to if somebody's been turned down then, if they've been turned down for a claim under either of the scheme, is there any other claims they could bring in that instance?
Well, the other claim that can be brought is the civil claim I mentioned. That differs from the schemes in a number of respects. One of the principal differences is you have to show fault in a civil claim. So you have to show on the part of the MOD that there's been some failure on their part to take steps they should have taken, or they've done something they shouldn't have done, and that has led to you getting the injury that you've sustained. On the other side, if you get over that side of it and you can prove fault, the level of compensation and damages that you can claim will be assessed by the court. And because of that, it's typically much more generous than you get under the scheme. In particular, the scheme gives flat payments depending on what the award is. But again, sticking with the hearing loss example, if you bring a civil claim through the courts, in addition to a lump sum payment, you can also claim, for example, for any hearing aids that you may need that you can pay for privately. And we also see a lot of individuals who have had to leave the military early and have lost a military career, and have also had their civilian employment affected because they're restricted in what they can do because of their hearing. That often results in a reduction in their earnings capacity, and that could be over a 20, 30, 40 year employment career. So that can be a very significant amount, and a civil claim will give you the option of including a claim for those amounts, whereas the schemes do not. So you can bring both together. The fact you're turned down under one doesn't mean that you're going to be turned down under the other. And it's important, particularly if you are rejected under the AFCS or the war pension scheme. It very rarely follows that that's an automatic bar to bringing a civil claim. Some of our most successful clients we've had were rejected under the schemes.
Okay, so you mentioned a couple of the differences there between a claim under either the schemes and a civil claim. One being you have to prove fault, and the other one being the amount assigned to a claimant, I guess. Are there any other differences with a civil claim and a claim under either scheme?
Well, the civil claim will need a solicitor typically. Again, in theory, you can bring that claim on your own, but the vast majority of people, for obvious reasons, do not do that. The MOD will certainly instruct solicitors to deal with it, and barristers in due course. So a civil claim routinely involves solicitors who tend to act on a no-win, no-fee basis. That's certainly the practice we adopt. The civil claim can take longer simply because if the MOD wish to contest that they were at fault, it will be necessary to prove that they were, and that's again where we can come in to help establish that. Rather than an application form, you have to submit a more detailed letter via the solicitor setting out what the reason is for the claim and take it forward that way. So it can take longer in a civil claim, but the ultimate outcome can be a lot better.
Okay. I guess from my point of view, it's a no-brainer really. If it's a no-win, no-fee arrangement, you're better off paying a percentage of something in a successful claim than getting it wrong yourself as an individual and not having a favourable outcome. So I think it just makes sense really to get a solicitor involved from the start.
Yeah, I think that's fair. I mean, the other issue, of course, is that a no-win, no-fee will give you peace of mind. You know that if it goes ahead and you're not successful, then you're not going to have a big bill at the end of it. If you are successful, then as you said, there will be a deduction for your compensation, but you've got the award of compensation at the end of the day, and you can also have confidence that what you are being awarded is the correct amount.
Exactly.
And that if the MOD have contested it, and they routinely do, that you can then have advice as to the actual damages that you're awarded, as to whether or not it is correct or whether you should press on and go to court if need be. So I think, it certainly will be in the interest of people to bring a claim through a solicitor if it is a civil claim.
Yeah, it makes complete sense to me. So what if somebody wants to bring a claim then, and they want a solicitor to do that? What's their next steps? How do they do that?
Well, civil claims also have their own deadlines. They can vary depending on the type of injury, and it depends on if the condition is such that there's a gradual awareness of it developing, and you may not automatically blame it on the MOD. We've talked an awful lot about hearing loss today, but it's another good example of this. A lot of people develop hearing loss, think it's down to old age, may not even realise they've got it, and it's usually their partner who's telling them that the television's on too loud and this sort of thing. And it may be difficult to pin down exactly when they first became aware of the problems and attributed it to, let's say, noisy military service. The best thing to bear in mind at this stage is if you think you have got a possible claim for an injury like that, see a solicitor as soon as possible. Speaking for ourselves, we will then advise you on whether we think you've got a claim. We can talk you through the no-win, no-fee arrangement and how that works, and we can talk you through the next steps. Delaying can be dangerous because if you miss the deadlines, that may result in you not being able to bring what would otherwise be a perfectly valid claim. So if in doubt, bring the claim and make the inquiry as soon as possible. The worst that will happen is that you're told that there's nothing that can be done, and then but at least if something can be done, you've then got the options as to what you do next.
Yeah, makes complete sense. As always, Simon, great sound advice. Thanks very much for taking the time out of your busy day and coming and joining us and speaking to everyone, a veteran of the UK.
No, not at all. Thank you, Scott.
Thank you.